Uh, uh, Hi. How are 1, 2, 3. Yeah.
Hearing will come to order. And let me begin by thanking Ambassador Jacobs and all of our distinguished witnesses and guests for being here today, especially the left-behind parents that I see in the audience for joining us this afternoon to continue and to increase attention on international parental child abduction, whose victims include primarily children denied the love and attention of one of their parents, and parents cut off from their children that they love. Every year, by some estimates, approximately 1,000 American children are unlawfully removed from their homes by one of their parents and taken across international borders. Less than half of these children ever come home. Most of the left-behind parents in the audience today have not seen their children in years and know all too well the financial, legal, cultural, and linguistic obstacles to bringing their children home from a foreign country. Many of you have already been through a U.S. judicial proceeding prior to the abduction, and the courts have settled custody and visitation only to have a kidnapping spouse defy a court order. Others of you were caught completely by surprise when a spouse's vacation turned into an abduction, a phone call in the middle of the night telling you that you will never see your child again. Your suffering is exponentially compounded by knowledge of the pain caused to your child by the separation. Child abduction is child abuse. Parentally abducted children are at risk of serious emotional and psychological problems and may experience anxiety, eating problems, nightmares, mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. These young victims, like their left-behind parents, are American citizens who need the help of their government when normal legal processes are unavailable or have failed. In 1983, the United States ratified the Hague Convention on the civil aspects of international child abduction to try to address abduction and access. This convention created a civil framework for a quick return of abducted children and for rights of access for left-behind parents. Absent extenuating circumstances, the child or children are to be returned within 6 weeks to his or her country of habitual residence for the courts there to decide on custody or to enforce any previous custody determinations. The convention has helped return some children, but implementation has been unpredictable and spotty at best. Susceptible to abuse by taking parents or judges who either don't understand their obligations under the convention or are unwilling to abide by them, the convention has too often been stretched to provide cover for the abduction rather than the recovery of the child. Some Hague Convention parties are simply not enforcing legitimate return orders. The State Department's 2014 Hague Convention Compliance Report highlights 4 countries, Brazil, Mexico, Romania, and Ukraine, that habitually fail to enforce return orders. Other countries, Costa Rica, Guatemala, Honduras, and the Bahamas, are non-compliant with the convention. In other words, abducted American children are not coming home from these countries and so many other countries where the convention operates weakly or with which the United States has no bilateral agreement of any kind. To give one more example, Jeffrey Morehouse, who a left-behind parent who will testify today, will say that there have been 400 cases of U.S. children kidnapped to Japan since 1994. We do not know of a single case in which the government of Japan has issued and enforced an order for the return of an abducted child to the United States. That is unconscionable. And I must emphasize that since they have signed the Hague, Japan's efforts have been breathtakingly unresponsive, especially for abductions that occurred prior to their ratification of the Hague Convention. Mr. Morehouse will testify that 1 year ago next week, at the very moment Japan acceded to the Hague Abduction Convention, parents joined us to hand-deliver 30 Article 21 access applications. I would note parenthetically, I joined those parents at the Japanese embassy. They were unbelievably respectful and disciplined and very, very cordial and yet very, very determined. None of the back-home parents, however, have received access to their kidnapped children. That's almost a year ago next week. Japan's implementation of the Hague Abduction Convention, Mr. Morehouse will go on to say, is an abysmal failure. Sanctions under the Goldman Act will provide some of the necessary public pressures on Japan to create change to this ongoing human and family rights crisis. Again, the status quo is simply not acceptable. Over the last 5 years, many of you are here today helped me and my staff write and pass through the Congress the Sean and David Goldman Child Abduction Prevention and Return Act, simply known as the Goldman Act. Today's hearing occurs more than 7 months after the Goldman Act became law and gives us an opportunity to hear from the State Department and parents whether the bill's key provisions are being implemented according to the law. A brief refresher on Sean and David. David Goldman spent over 5 agonizing years trying to legally rescue his son, Sean, from abduction to Brazil, which is a signatory nation like the U.S. to the Hague Abduction Convention. Despite Mr. Goldman's airtight case that demonstrated an egregious example of both child abduction and wrongful retention, the Hague Treaty was unavailing, and the outcomes in the Brazilian courts proved mostly infuriating, infirm, and ineffective. David Goldman weighs his case by the book and won judgments in New Jersey courts, yet both Sean and David were made to suffer emotional pain for over half a decade as one delaying ploy after another was employed by the abducting party. In the end, because of a father's abiding love for his son and an indomitable will, like so many of you here today who have suffered so much, the Goldmans today are united and happy, unlike you who still are separated. To underscore, the Goldman Act was not intended to simply reform the system, but to bring about a fundamental sea change in U.S. diplomacy so that the State Department officials would see themselves as advocates for the return of abducted American children. Now under the Goldman Act, when a country fails to appropriately address an abduction case pending for more than 12 months, the law requires the Secretary of State to take action. When a country has more than 30% of its U.S. cases pending for more than a year, the law requires the Secretary of State to designate the country as non-compliant in the annual report and take action. The Goldman Act specifically lists the increasingly escalating actions that Congress has in mind, from a demarche or protest through diplomatic channels to a public condemnation to a delay or cancellation of one or more bilateral visits, and even the withdrawal, limitation, or suspension of foreign assistance, including non-humanitarian aid and including security assistance to the central government of a country. These are serious sanctions that must be seriously applied by a country that takes parental child abduction seriously. We may also request extradition where appropriate. If these measures sound pointed, it is because they are intended to focus the designation country on quick and accurate resolution of abduction and access cases, and we hope to find out today from Ambassador Jacobs how these tools are being used and with what frequency. The Goldman Act was written to cover countries that have signed the Hague Convention, such as Brazil, and countries that have not signed the convention, such as India, and countries that have a mix of open abduction cases from before and after signing the Hague Convention, such as Japan. In 2013, India was the number 3 destination in the world for parents who were abducted from the United States. Currently, there are 64 known open abduction and denial of access cases involving India. And yet the United States does not have any sort of resolution mechanism, to my knowledge, in India or with India. Moms and dads are left in the United States or forced to enter a foreign court system known for its incessant appeals and multi-year delays and even mega intimidation. But now the Goldman Act applies. India will now face real penalties for any case that has been pending for more than 1 year and will be named and shamed in the State Department's report. As with the State Department's annual trafficking report, there is morally suasive value in simply reporting what a country does, and some countries will, I am sure, respond to such moral pressure. Thus, we expect the State Department to apply these penalties zealously and to work with India on establishing a bilateral agreement for the efficient and fair resolution of abduction and access cases. If the State Department faithfully applies the law as written, it will be in India's best interest to come to the negotiating table. The same holds true for Japan. Even though Japan recently signed the Hague Convention, in the upcoming April report, Congress expects that Japan will be evaluated not just on its handling of new abduction cases after it joined the Hague last year, but on its work to resolve all open abduction cases, including the 67 cases that I and others have been raising with state for the last 5 years. Among such cases is that of Michael Elias, who has not seen his children, Jade and Michael, since 2008. Michael served as a Marine who saw combat in Iraq. His wife, who worked in the Japanese consulate, used documents fraudulently obtained with the apparent complicity of the Japanese consulate personnel to kidnap their children, then aged 4 and 2, in defiance of a court order, telling Michael on the phone, call that there was nothing that he could do. She said, quote, "My country," that is Japan, "will protect me. Her country will protect her, but what is our country doing to protect Michael and his children?" While the State Department has touted Japan's accession to the Hague Convention as an accomplishment, Japan has said the convention would only apply in post-ratification cases. As Ambassador Jacobs knows, I and several others predicted that unless an MOU or other bilateral agreement was concluded with Japan, American children and their left-behind parents will be left behind in perpetuity. I asked my friends at the State Department once again, what then is to happen for the parents already suffering from abductions prior to ratification? Would they be left behind again, this time by their own government? I know Ambassador Jacobs, who was here to testify as recently as February 2014, in her testimony before the Senate, stated that she would continue to make progress with the Japanese government on resolving existing cases in the spirit of the convention. We will have a chance to ask the ambassador what progress has been made on resolving cases like Michael Elias, Captain Paul Toland, and so many others who are suffering every single day. And I'm sure when they wake up in the morning, it's the first thing they think of. The Goldman Act requires accountability for the Japanese government on the adoption cases open at the time when Japan signed the convention. Unless Japan resolves scores of American cases before the end of next month, nearly 100% of abduction cases in Japan will still be unresolved, and the Goldman Act penalties will apply. The Goldman Act has given the State Department new and very powerful tools to bring Japan and other countries to not the negotiating table, the resolution table. The goal is not to disrupt relations, but to heal the painful rifts caused by international child abduction. I look forward to hearing testimony on the Department's use of the tools, and I would now like to yield to Dr. Burra, serving as acting ranking member, for his opening comments.
Great. Thank you, Chairman Smith, and I want to thank Ranking Member Bass as well for calling this important hearing to discuss the issue of international child abductions and the Goldman Act. I also especially want to thank the chairman for his tireless effort and work on this issue. I also want to thank the witnesses and the left-behind parents for your heartfelt testimony today. I understand it obviously cannot be easy, but it's incredibly important to hear these stories. As we'll hear today, this is a serious issue. Approximately 1,000 U.S. children are reported to the State Department as victims of international child abduction annually. These abductions are devastating to families, especially to the children. Many of these children are too young to know what is occurring and are isolated from their left-behind parent. The left-behind parent has to go through a stressful and expensive legal process, and as we'll hear today, not always successfully. One avenue to pursue in order to combat this issue is to push more countries to sign the Hague Convention. This brings those nations into a legal framework in which they can resolve the issue in a more effective manner. This, however, is not a panacea, but it's a good first step. In addition, just signing onto the Hague Convention doesn't solve the issue if the countries don't adhere to what is in there. I'm going to implore the State Department to continue to push more countries to sign the Hague Convention and continue to work on reuniting left-behind parents with their children. And again, I just want to commend the chairman for your tireless work on this issue.
Thank you, Dr. Burr.
Thank you.
I'd like to now yield to Mark Meadows.
Thank you, Mr. Chairman, and Ambassador Jacobs, thank you for being back with us. It is good to have you here. You expressed your heart the last time that you were here, and I think that was evident because one of the troubling things, I think, for parents, and I met one parent yesterday in the hallway coming between the Capitol and back to the offices. But one of the difficult things for a lot of parents is they see other things that the State Department is engaged in. Not you, but other things that the State Department as a whole is engaged in. And what they have come to the realization, or at least the belief, is that it is not a priority for the State Department to return these children. And because of that, it is very difficult as a dad, because you empathize with just the thought of not being able to visit or see your children. that priority. So I'm looking forward to hearing from you today on the progress we've made since the last hearing where we had a chance to hear a little bit from your heart. But I want to put it in the context, when we see the State Department, and when we see 5 Gitmo prisoners being traded for a potential deserter, and we see that kind of priority from the administration, and we don't see progress here, what happens is there's this balance that goes out. And I'm not trying to be critical of that decision or of your agency. I'm just saying there's a natural assumption that says, well, if they would make the same priority for my son or daughter, I'd get to see them. And so I hope that we hear some of that from you today. I do appreciate you coming back and the emphasis that you put on it. And I'll yield back to the chairman.
Thank you very much, Mr. Meadows. I'd like to yield to Ms. Walorski, who has been working tenaciously on a case of one of her constituents out of Cyprus. Ms. Walorski.
Thank you, Mr. Chairman. I am grateful for your efforts and for the help that you've given me and remain grateful. I'm grateful I'm allowed to come as a non-member. The Honorable Ambassador, I actually came to seek your help. And I really am, in this short amount of time in an opening statement, just want to familiarize with a case that I'm working on in the state of Indiana. I've worked on this for 3 years. The case has been active for 5. And I know this is small, but forgive me, this actually just came from Cyprus. These are my constituents. This is Marla Smith Theocarides, and her kids were kidnapped in Cyprus. And there's domestic problems in my district in Indiana. This couple was divorced. We've been working through every single legal channel there's been trying to secure the release of these kids. And I literally came here today, and I'm grateful to this chairman. I was so thrilled to hear that the Goldman bill passed and that there maybe was some help for people in my district. Because, I look at this, and you've done phenomenal work on this. I'm here in my role, as a congresswoman representing these kids and this mother. I'm also here as a fellow advocate on domestic violence and the things that we've all worked on our whole lives. But I'm appealing to you in the position that I have to say we need help. We can't move the Cyprus government. We've used every law that we can. They're completely ignoring it. They're denying any kind of help for this woman and these kids. And it's an honor for me to actually just be able to sit here and have engaged in a conversation with you just to try to get your help. Because you know what? And my point earlier to you, and again, for the record, is I am not a believer in domestic violence. I have fought domestic violence my entire life, all over the globe, not just my district, but in places like Eastern Europe and Romania, where my husband and I were missionaries. And back to the chairman's point, these are American kids. This is a mother of 2 kids who's lost access to these kids, has no help whatsoever from the government that she's trying to comply with. We've gone through every channel possible, and there's police reports filed of this estranged husband coming back, perpetrating violence on her. There's violence being perpetrated on these kids, and they're American citizens. And I just would implore you and grateful to you, so thankful that you're here today, thankful that I'm allowed the opportunity to make this case, but just wanted to make you aware of it. I'm definitely going to follow up. But just asking for your help on behalf of these constituents in the state of Indiana. Thank you, Mr. Chairman. I yield back.
Thank you very much. I'd like to now introduce our distinguished ambassador, Susan Jacobs, currently serving as special advisor in the Office of Children's Issues at the State Department. Ambassador Jacobs has a long and distinguished career in the Foreign Service, in which she served around the world, including in Papua New Guinea, where she served as U.S. Ambassador. She has also held a number of senior positions with the State Department in Washington, including serving as liaison to both Congress and the Department of Homeland Security. Ambassador Jacobs, please proceed.
Thank you very much. I'm going to put on my glasses so I can see. Chairman Smith, Acting Ranking Member Bera, and distinguished members of the subcommittee and their guests. Thank you for the opportunity to address you again regarding International Parental Child Abduction, or IPCA, and the implementation of the Sean and David Goldman International Child Abduction, Prevention, and Return Act, or ICAPRA. I ask that my full written statement be entered into the record.
Without objection, so.
First, I want to say to the families that we really feel for you, that your pain is our pain, and we really are working very hard to resolve these cases with all the resources that we have available. I want you to believe that because it is the truth. In that regard, ICAPRA represents a joint effort by the Congress and the executive branches both to resolve these difficult and painful abduction cases and to prevent their occurrence. I'd like to speak about the steps that the Department of State has taken to implement ICAPRA in the past 7 months. A team of over 80 dedicated employees charted initiatives that built on the best practices that we and the parents have developed as we work to resolve these cases. The Office of Children's Issues, which acts as the U.S. Central Authority under the Hague Abduction Convention, helped resolve 781 international abduction and access cases last year. We continually look for ways to improve the service we provide to abducted children and left-behind parents. ICAPRA provided an opportunity to improve our procedures and increase our effectiveness. Many of our initiatives are driven by the annual report's new data requirements for collecting information on all countries. Ours is a work in progress, but we have realized improvements in case management and data analysis, and after the report is published, we welcome your feedback. We also focus on education and prevention. We regularly train offices about abduction issues, and the department instructs its diplomatic missions to engage with host governments about the convention and to promote it through public diplomacy. We continue to work with the Departments of Justice and Homeland Security and the Federal Bureau of Investigation on Operation Prevent Departure. I chaired the first interagency working group meeting last October, and we are having another meeting in April. And we have invited the Department of Defense to join our next meeting so that we can include them in the planning that we do on this important issue. We have also met with the U.S. Navy Judge Advocate General's Corps and the Director of DoD's Office of Legal Policy to provide an overview of the law and its impact on the military community. Judicial outreach is an essential part of our strategy to prevent and resolve abduction cases. We educate the broader community of judges in the United States by providing information directly to judges hearing a convention case, and we have updated and enhanced information on our website. There are 4 U.S. judges who serve on the International Hague Network of Judges, and they assist domestic and foreign judges to resolve many convention cases. In the past year, U.S. officials, including me, have traveled to over 25 countries for bilateral discussions on resolving IPCA cases and promoting the Hague Abduction Convention. Our diplomatic efforts increase the likelihood that our future and current treaty partners will meet their responsibilities under the convention. We have begun to identify countries as candidates for bilateral arrangements and to evaluate whether non-convention countries have demonstrated patterns of noncompliance as defined by the law. Department officials regularly engage with foreign governments of non-convention countries to encourage those countries to become parties to the convention and to address pending abduction and access cases. One example is our decade-long effort to secure Japan's ratification of the convention, and we are working to improve our relationships with the Japanese Central Authority and the Japanese Foreign Ministry so that we can resolve all outstanding cases. We continually advocate for left-behind parents and support Japan's own development of resources for resolving cases. The convention also provides an excellent platform for multilateral diplomacy. In 2014, we hosted a regional symposium on the convention in Jordan and participated in regional meetings sponsored by the Hague Permanent Bureau in Beijing and in Kuala Lumpur. The Kuala Lumpur conference specifically addressed the compatibility of the Hague Abduction Convention with Sharia law codes and included presentations from several predominantly Muslim countries. We have made maximum use of a few short months to begin implementing ICAPRA's requirements. We're building on a strong foundation of good practices. Your support remains essential to our success in maintaining IPCA resolution and prevention as resources in our bilateral relationships and in advocating for membership in the Hague Convention. We are committed to achieving our shared goals to increase the number of children returned to their habitual residence and to create safeguards that will minimize the occurrence of international parental child abduction. Thank you very much for the opportunity to be with you today, and I look forward to your questions.
Very much, Madam Ambassador. If I could begin your testimony just a moment ago, you talked about how the USCA has assisted in the resolution of 781 abduction and access cases. Can you tell us how many of those cases deemed resolved were actually returns?
I do not have that number, but I can get it for you. I mean, because resolved cases to us are returns, either voluntary or court-ordered, or, you know, or the case has been closed either by the parents or because the child has aged out and has become a different kind of case for us. It's not that we're forgetting about
No, I asked that because even like an aging out issue at 16 for Hague countries, for example, what they tried and have done to so many of the abducted parents globally, including those whose children were taken to Japan. David Goldman's case was, they were running the clock on that one to try to get Sean to 16. It would be and I would hope the press would take note of this, it's wrong to talk about that as resolution without delineating how many of those children came home. Could you, maybe someone could
I'm gonna
get that to us before the hearing's over?
That number probably tomorrow or Friday.
Any chance of getting it now? You know, somebody back
I don't think
headquarters?
we have it. I'm sorry. I didn't know that you were going to go into the numbers.
Well, that is all important because the headline of 781 resolved cases does sound very efficacious and very encouraging. But again, when you talk about aging out or a parent who after a year hasn't been in touch with the department and he or she, the mom or dad, find out that, you know, that they've been dropped. We've been very concerned, and we hear from the parents that they're so concerned about drop cases. You know, I want to know how many came back.
I'm going to get you that number.
And none from Japan, as far as you know, right?
As far as I know, there have been none from Japan, but there was a court-ordered return just last month.
You know, on the visitation issues, you point out, and properly so, as I mentioned in my opening comments, about how with Japan, even on the access cases, 31 convention access applications, none of those have been honored either. And that is, I mean, that is outrageous. A year later, and I sat in that meeting, and the Left Behind parents meeting with Japanese officials a year ago next week were like the ultimate diplomats. I was boiling listening. You know, they were respectful on the other side of that table, but it was like, please, you know, I've been in this business for too long, 35 years as a member of Congress. Let's talk resolution. And there was talk of endless delay. And now a year later, none of those access cases even have occurred.
I know that it's frustrating, and we share your frustration, and these are issues that we continue to raise with the Japanese. We talked to them in September. There was an International Visitor Leadership Program in February, and then another visit from the Foreign Ministry, and we have raised these concerns at every one of those meetings, and we plan to go back in June. And I talked to Ambassador Kennedy yesterday, and she is energized, and she is ready to launch.
If I could ask you, in terms of the return, if you could give us that information for each country. I mean, Japan, India, I mean, it was the NCMEC, the National Center for Missing Exploited Children, that said the number is 64. Bindu Phillips, who will testify, sitting right directly behind you, almost 7 years. Matter of fact, she not only has had her children kidnapped, as Eamon Blanchard, who is a police officer who's with her today, as the Plainsboro police have documented, there's been one violation of her rights. Money was taken, all the furniture was cleared out, loans. I mean, it was a very high level fraud. In addition to I mean, she was broke after this happened by the abducting father. And back in India, she's being frustrated beyond words. And as you know, and this goes for Japan, it goes for any country, Section 201 makes clear that determination of action by the Secretary of State for each abduction or access case relating to child whose habitual residence in the U.S. that remains pending or is otherwise unresolved on the date that is 12 months after the date on which the central authority of the U.S. submits such a case to a foreign government, the Secretary shall determine whether the government of such foreign country has failed to take appropriate measures, and then he is then, as expeditiously as practicable, told, admonished, delineated in the law to take one or more actions described in Section 202, which is the sanctions provisions. It seems to me you have a textbook engraved invitation to be serious in implementing this law, to say, Japan, we could take any one of these cases. Paul Tolan, you know, he served in Yokohama as in the Navy, and he is the only surviving parent, not unlike David Goldman, because his wife had passed away, and he, like the others, live in agony over the loss of their child. She's, I think, now 11, his little daughter. That is a textbook case for us to say, Section 201, Japan, we're going to use this. Because, again, the access cases should be a clear suggestion, if one is needed, that Japan is not living up to the letter or the spirit of comments that have been made, as well as signatories to the Hague Convention. And in their case, they're excluded and not included in its implementation by definition. So if you could take back and maybe respond to it now, could you use Section 201 for Bindu Phillips or for Paul Toland or any of the left-behind Japanese parents whose children were abducted to Japan?
Absolutely, because we do it now. We have not waited for that year to run. We raise these cases constantly, especially with the countries that you have named, in an effort to resolve the cases.
Can I
and
respectfully-
can I
I
tell
don't-
you that I share your frustration?
Good, thank you. Can I just say, and I really believe there needs to be a look at, I mean, there are a number of tools in the toolbox in terms of sanctions. Look at the sanctions that will have bite. I mean, a demarche is a good shot across the bow, but that's all it is. And you've done that with Brazil, for example. But I think the next step has to be, okay, you've not resolved these cases. And you tweeted back in 2011 how you've put together a working group in Brazil. Is there any fruit to that effort? Are people coming home? Children?
Let me express my frustration with our progress with Brazil. I have made 6 visits to Brazil, and we've had one return, and it isn't enough. But we have had a breakthrough, and I've been invited to go back and to meet with judges to express our frustration, because in Brazil, that is where the problem is. And we've invited judges up here. We had 10 judges here in September. We're putting together another program for judges, and we are looking at every way we can. The ambassador's very engaged. We are trying to work with the Brazil Central Authority, a very responsive organization, to get the judges to implement the convention the way it's written.
When Secretary Kerry testified on February 25th before our full committee, I asked him specifically about the meeting with Prime Minister Modi by both himself in January and, of course, the President of the United States, Barack Obama. And I asked whether or not child abduction cases had been raised, and I'm not sure he answered it, and I have deep respect for the Secretary, but he said anytime that I visit, either home or go somewhere, we meet at high levels, we raise these issues by name. I'm not sure he raised Bindu's case or any of these cases, but my question to you is, it would be nice to have clarification on that, but in our newfound relationship with the Modi government, is this an issue at the top, along with other issues at the top? I mean, if we can't speak out for abducted children, American children, who will?
It is an issue at the top, and let me assure you that
Did President Obama raise it?
I don't know,
Could
because
you get back to us on that for the record?
I'm going to be really honest with you. I don't know if that information will be given to me. But what I can
that
assure
secret?
you of is that when we learn that high-level people, including the secretary and the undersecretaries, are traveling to countries where we have problems with abduction cases, we put something into their briefing book so that they will raise this issue.
And I
This
deeply
is-
appreciate that, but the question is it delivered, or is it on page 5 of what they find, and they never get to it?
It is
I mean, we
not-
found that with David Goldman at first. It was, there was pickets out in front of the White House to try to get a focus when Lulu, the president of Brazil, was coming. And finally, at long last, it was raised. We're not sure if it was an afterthought or a real, I mean, foreign leaders, as we all know, look our foreign leader in the eyes and say, is this of high importance, or you're just putting a little check in the box? And I would hope there's nothing secretive as to whether or not the meeting with Prime Minister Modi, and this would go for the Prime Minister of Japan and every other meeting, this has to be front and center. And now sanctions ought to be utilized. If we use sanctions, and I made this point when I did the Trafficking Victims Protection Act, if you don't use the sanctions, this becomes an unimplemented law and a toothless piece of legislation. They have to know it's a priority, and the meting out of sanctions, and I mean real sanctions, would immediately cause them to wake up, and you will have tremendous successes on your hands with children brought home.
If I might, I can tell you that I have already had some successes in just the threat of sanctions invoking this law. In recent meetings in Guatemala and Honduras, where we have had very little success on abduction cases, we got their attention, and now there is going to be far better cooperation.
That's encouraging, but those are very small countries that can be more easily persuaded, to use a diplomatic term. Intimidated might be a better word.
No.
But the big countries, Japan, India, this has to be far more important.
Absolutely. They have, I am planning to go to India in May, to Japan in June, and to talk about the report. The Indians don't want to be cited, and I do think that public shaming is a very good thing for countries that are not doing the right thing.
Can we expect India will be on the non-compliance?
We haven't put together the
Non-cooperation, I
list,
should
but
say.
I don't think you'll be
Non-cooperation.
disappointed.
Okay, let me, also in your testimony, you say, as we execute the new requirement to inform members of Congress directly of new IPCA cases, let me just say, the language is clear that all cases should be informed. Is there a more narrow reading of the text? I mean, a new case, I mean, all of the old Japanese cases, some of them are 10 years old. It would seem to me, and I've asked many members of Congress, is there anybody in your district that you know of? And one after the other, it's a blank stare. No, nobody's contacted me. Are you informing all people that their congressmen and 2 senators could be tremendous advocates for the return of their children, or access, or both?
We are, in April, we will begin the notification process to members of Congress. We have had to work through other laws to make sure that we are doing the
Privacy,
right
of
thing,
course.
and we will begin doing that in April.
Okay.
And thank you for that question.
Okay, and it'll include old and new cases?
It'll
Not just
include
since
all the
enactment.
cases for which we have permission to give them information.
Okay, that's good. So strike that new word in the, Ms. Bass.
Thank you very much, Mr. Chair. As usual, this is an issue that you've championed for many years. I'll share with my other colleague there. I remember years ago watching the case in Brazil, long before I ever knew I would be coming to Congress, and then I get to sit next to the person that championed it. So, along with your leadership for many years, I just have a couple of questions. I wanted to know if you could describe how our government is engaging in efforts to prevent these abductions from taking place in the first place, and how our government measures the effectiveness of programs to prevent the abductions, and then what actions has the State Department taken to encourage mediation as an option for returning children, especially to return children from countries that are not Hague Convention participants?
Thank you so much for those questions. We have a number of programs to protect children from abduction, some of them of longer standing than others. All of them are really a part of the Operation Prevent Depart. So we have, for children under the age of 16, a 2-parent consent rule, which means both parents have to give their permission for a child to be issued a passport. And we also have a passport alert program where a parent who feels their child will be abducted can notify us, and we will put an alert in the system so that a passport will not be issued unless the parent who put the hold in is notified. And it's hard to know what the success rate is, but it is a deterrent, and it works. We also work very closely with Customs and Border Protection to prevent departures from the United States. We also have the Prevention Working Group that I chair with members from Justice, Homeland Security, it will include Defense now, and the Federal Bureau of Investigation. And we work on new programs. This is mandated by the law. It's something that we had started doing before, and we do work very closely with law enforcement, and I think it's effective. As you know, it's easier to prevent the abduction than it is to get a child back. Right. And so we need to do everything that we can, and we look forward to working with you all on strategies that will prevent children from being abducted. That's the big thing that we can do.
And I'm wondering if some of the procedures that you're describing are new. I have to tell you, while you were describing the thing about the passports, there's all these heads behind you shaking no. And so I don't know if that's a new procedure.
The 2-passport consent rule in 2008 was instituted in 2008.
I see. That's relatively new.
It's new, and it is something that we encourage other countries to do.
Have you ever had a situation where you were able to, one of the problems with prevention is that it's hard to document something that didn't happen, right? But I'm wondering if you ever had a situation where you were able to literally stop it versus, you understand what I mean?
Yes, absolutely. In a couple of, we are fortunate enough to be able to use passport agencies, especially in California, to place prevention officers. And we also have officers in Europe. So we have almost 24-hour coverage where parents can report an abduction in progress. And last year we stopped one in San Francisco.
Oh, while they were trying to board a
While they were trying to get into Canada, they were trying to get on a plane to get into Canada. And I'm sure you all read about the case at Dulles where a mother was trying to take her child to China and they turned the United Airlines flight around.
No.
When the father... I'm sure the other passengers were annoyed, but we thought it was a great success.
When did that happen?
It happened last fall sometime.
Wow. Okay, I yield back, Mr. Chair.
And you asked about mediation.
I did. I'm sorry.
We participate in a mediation working group that consists of Sharia law countries and non-Sharia law countries. And mediation does work, and it's something that we suggest to parents. I don't think it's a substitute for the legal recourse that's available in the Hague Convention, but it is something that parents should try if they think it will work.
Thank you very much, Ms. Bass. Mr. Meadows?
Thank you, Ambassador, for being back with us. And as I go into this, I want to ask just a couple of questions as a follow-up of some of the other things that have been mentioned. And I guess for me, when we talk about open cases and we talk about the breadth of this problem, is it growing or is that number going down?
It's about the same. Now, you have to remember, though, that it's all self-reporting. If somebody doesn't notify us about a case, then we're not going to...
You can't know about it if you're not notified.
Right.
But what you're saying is that we have the same number of open cases. It's been flat.
I can get you real numbers.
Which I guess, well, let me ask if the logic, if it's staying flat, And what is that number? I mean, about what are we talking about? How many?
About 1,000 cases that are open.
So if we have about 1,000 cases, and as the chairman was talking about, some of those are aging out and being closed. So we have new ones coming in, and I guess the same number going out. That's not necessarily a direct result of successes within your department. Is that, I mean, what percentage, I guess, is your actions versus just they're growing old, or they're closing the case, or they worked it out on their own?
I would argue that a lot of it is due to our actions. I think that membership in the Hague Convention, even while it is slow and often frustrating, does provide a legal framework and a way to work with countries both bilaterally and multilaterally to get their attention and to get them to enforce the convention. In a lot of countries, like Brazil, we do work with other countries to present the same message to the Brazilians that we are giving them. And that becomes a strong message. I think laws like ICAPRA also help us. And kidnapping is a crime in the United States, and I think people often look to a civil remedy rather than a criminal remedy, so that if a taking parent is found out of compliance with the law and the child is returned, they would still be able to visit their child in the United States under some circumstances. So I think that it is a combination of a lot of things. But I think that the Hague Convention remains our best tool for helping to ensure the return of abducted children.
All right, so we have some tools. We have the law that the chairman's referred to. We have, a department that's committed to this particular issue. We have a number of tools that are out there. I'm sure you'll get to hear from Ms. Walorski here in just a few minutes. How do we, as members of Congress, come alongside you to make this a priority? Because I'm very sensitive to the fact that you've got a difficult job at the State Department, and there are a number of moving parts, and I try to stay out of that as much as I can, even though it's a passion. But does it require a few members of Congress getting on the plane and going down? I mean, would that be helpful? Or the next trip that you have, that we come in and we show that it's a priority more than we have?
I think it would be great if, when you all travel, that this is one of the points that you raise with foreign legislators and others that you meet. I think it's an incredibly important issue, and we want to be your partner in resolving these cases. So I would welcome that.
But I will say the other side of that, though, Ambassador, is this, that if we had these tools and we never plan to use them, then the threats or the persuasive power, you might say, becomes a lot less, because what happens, a lot of these countries don't believe that we ever plan to sanction them. They don't believe that we're ever going to cut off foreign aid. They don't believe that it's really a priority. And let me go a little bit further, because one of the concerns I have is that when I talk to people in the State Department, regional bureau assistant secretaries, and people with regional, they don't even know that the problem exists. Or so they claim. So I'd love you to respond to that.
Well, if they don't, then that's a failing on our part, because we have certainly done our best to educate them about the importance of this issue.
All right, so do you meet with them regularly and give them a list of priorities in terms of people, children that have been abducted? Do you have regular meetings with the different regional assistant secretaries?
I certainly meet with them as necessary, and when there are cases that need to be resolved, I pick up the phone and I call them.
Yeah, but if you're not doing that as a part of your regular, here's what happens, is you pick up the phone and it becomes a priority for that day, and if you're not coming back, just like with you getting prepared for this hearing, the fact that you're coming back, I assume that you did a little bit of prep. I may be surprised, but But it's the same kind of thing with the assistant secretaries. And what I'm hearing is from a whether it's the Asia Bureau or wherever it may be, is they're not hearing the priority. And so do we have your commitment that you're willing to start scheduling those meetings in those troubled areas? I'm not talking about all over the world, but we know where the biggest source of the problem is. And if you would have those regular meetings where they say, well, gosh, here comes Ambassador Jacobs again, we've got to get some, it makes it a priority. Are you willing to do that?
I certainly am, and we actually have a meeting scheduled with the Western Hemisphere countries on April 22nd.
Okay, then.
But can I just add one thing?
Certainly, we're looking for solutions, so you add whatever you can add.
Our country officers in children's issues speak with their counterparts on the desks, the regional desk officers, every day. So they know, and this message gets carried up, and our assistant secretary, or acting assistant secretary, speaks out at the meetings that she goes to with the secretary. So this is an issue that everyone is aware of. When we know that the secretary is traveling, we get a point into his briefing book on that country.
But having an awareness, and I'm following your words, having an awareness and making it a priority are two different things. I mean, I have an awareness that my feet hurt, but until I do something about it, well, I don't want to continue to press you on this, and I'm trying to take off my oversight and be kind and compassionate about this because I do know your heart. But what I'm saying is I don't want to have another hearing a year from now and us to have a flat line in terms of the number of cases.
And I appreciate that, but let me assure you that the secretary, having been a senator, he knows how important this issue is, as did Secretary Clinton, who had also been a senator, and they truly care about this issue. And so the secretary has made it a priority to resolve cases everywhere around the world.
All right,
and I promise you that we will hold those meetings, and we will do it regularly.
And if you can just give us maybe every 6 months.
I'll give you the highlights.
Well, if you'll just give us a report of who you've met with and the highlights, that will help us figure out if we need to get other members of Congress to follow up on it. But thank you so much.
Absolutely.
I'll yield back, Mr. Chairman.
Thank you very much, Ms. Meadows. Ms. Walorski.
Thank you, Mr. Chairman, again. And Ambassador Jacobs, Marla, Katerina, and Marcus, again, these are my constituents. They're in a desperate situation, and I'm here again on behalf of them and in my role as well, is basically to ask you in your position, and I know you've done great work, and I know that there's, like you've said, 1,000 cases open. These two happen to be my responsibility. So what is the State Department's overall strategy in Cyprus? Is there a trend? Do you see more of this happening? Are my two constituents and three constituents the only people trapped in this whole kidnapped children, desperate situation, violence in another country? What is the overall situation in Cyprus that you know of?
I don't know of any case other than yours, but I will certainly check. I know that our counsel there, Steve Royster, has been very active on your behalf and on behalf of the children. And we will continue this pressure. And as I told you when we met before the hearing, I will go to Cyprus. My daughter was born there, so I have a special affinity for Cyprus. And I will also meet with the Cypriot ambassador here and impress upon him the necessity to resolve this case for Mrs. Theocharides.
I really appreciate it. I'm grateful, and they're grateful, and I'm sure their families are watching today. And I know that again, when it comes to how helpless these families feel, and for all the families that are in this audience today, but how helpless we all feel when these are American citizens. We would not tolerate this kind of violence in our country. And when things become desperate like this, I'm just grateful. And I will tell you that Ambassador Steve Royster, although I've never met him, has taken my call in the middle of the night many times. I look forward to meeting him. He's been an incredible help. The State Department overall has been helpful, but it just seems like it's just been nothing in dealing with the Cyprus government, one roadblock after another, after another, after another. So in your position of authority and based on what we're talking here today, with this issue of being able to sanction, I mean, I look at that as an open door that we really have not had before. So I appreciate it. And I just have one other question.
Yes, ma'am.
I have another issue that I just want to bring up quickly. It's the Democratic Republic of Congo on these issues where the president suspended the adoptions. I've got also adoptive parents in my district that have a heart of gold, that have adopted these children. They legally went through. They're trapped in the nation. They've shut it down. I've dealt with that with Romania before. What is the status right now? Is it a presidential issue? Are you working on it? Where are we on this, on the issue of the Congo?
I can't tell you how frustrating this issue is for me. I went to Congo in December to talk to them about this. They promised that there would be an interministerial meeting that would make me very happy. The government changed 2 days later. The meeting never happened, and I'm still really unhappy. Our acting assistant secretary was there last week. They promised the same thing, and nothing has happened. We are reassessing what we do. We have bent over backwards to meet some of their demands, to show them how loving families can make such a huge difference in the lives of children that are living under terrible conditions in foster homes and orphanages in the Democratic Republic of Congo, and we are not getting a lot of traction. And we have allies in all the other countries that are seeking to help children find permanency. We are hoping that they will attend the special commission meeting in The Hague in June so that they can hear from all of us together in person that adoption can be a great thing for a child, and especially for children who are unable to find permanency and a loving family in their own country.
Well, I would just echo, because I have had firsthand experience in the nation of Romania when we were there, and there was a moratorium on adoptions, and I think it's an outrage when there's willing parents, and I think it's an outrage as a government to use children as political pawns and tools, and we see it all over the world for all kinds of different things, but I would just would echo, I guess, your frustration as well. If there's anything, and to my colleague, Mr. Meadows, if there's anything we can do as members of Congress to put additional pressure on these nations to be able to comply and to not use these kids as political pawns. You know, they sell them multiple times. They never release them. They suspend them. There's so much gimmickry that goes on. I would just appreciate if there's anything else that we could do to assist you. I would welcome it and definitely be an advocate. So,
Thank you.
Thank you very much for you. I
appreciate
yield back, Mr. Chairman. Thank you.
Thank you very much, Ms. Walorski. Just a few final questions. What is the number right now of open abduction cases, and how many children are we talking about as of today's date?
You're going to be angry with me, but I don't have the number. I'm going to get it to you as quickly as I can.
Okay. Could anybody behind you maybe get that from headquarters too?
We'll get it for you.
You know, again, Jeffrey Morehouse in his testimony, and I do hope if you can't stay to hear it, you'll take it and read it, as well as our other distinguished witnesses. But he goes through specific cases, including Henrik Teton, who a request for interim access to his children under The Hague was ignored by the court, and goes, I mean, the obstacles that are placed in front of these parents are almost insurmountable unless our government establishes, in my opinion, an MOU to finally, at long last, have a mechanism that works, that's predictable, that's effective, and does not bankrupt the left-behind parent, which many of these offending parents know will happen over time because they just can't, they've run out of money, and their hearts are so broken that they collapse with exhaustion. Are MOUs being considered? And I've been pushing this. You know, I went to Japan with Michael Elias's mother. So I went with the grandmother of the two children, Jade and Michael, who had been abducted. And the whole pushback was no MOU, no MOU. You've and others have suggested that this wouldn't be helpful. We now know that there's been no relief for these parents and these children. These are American children. And it seems to me that a mechanism that could be invoked to expeditiously bring those kids back and that goes for India, a non-Hague country. If they sign the Hague anytime soon, we'll be right in that same boat, and Bindu Phillips will see 7 years become 8 years, become 9 years, become 10 years. And again, I strongly ask you, take her case, meet with her, please, but take her case and use that to invoke Section 201. You only need one case. And you only need one case from the folks who have had their kids abducted to Japan, and then implement the sanctions. Until we do sanctions, I do believe, respectfully, they'll think this is a paper tiger and we're just going through the motions rather than being serious about this. And again, security aid can be sanctioned. While Japan doesn't get a dime, I'm sure, of foreign aid because they are a very, very mature democracy and they're a donator of foreign aid to refugee causes and other very, very laudable commitment by Japan, but they do rely on a security, and as we know, and we've had witnesses here, and of course Paul Toland, he had Shinkin invoked against him, and I do hope there's something we're doing to say, this sole rights over the child, and in this case, Paul's child, his daughter, is in the hands of a grandmother. There is no mother. She has passed, sadly, but she's passed. And Paul still now, a decade later, has not been able to get his daughter back. And I just add one other thing. Patrick Braden is here. I joined him at Melissa's birthday party. I believe she was 4 at the time. We couldn't even get in to see the Japanese leadership or embassy people at that time. Now that's, 6 years ago. Every one of these wonderful mothers and dads that I meet and you meet, they've been put through an agonizing process. So an MOU and a prioritization, sanctions, and say, look, we're not kidding. The Goldman Act, and I don't call it the anachronism you do it is the Goldman Act. Once there's more than 4 letters, I usually think, well, there's VAWA or something else. After that, it's better to go with Goldman Act. It just seems to me that the time has come. And if we invoke sanctions, name the name, put them on the noncompliance in all 3 of those countries, Brazil, India, and Japan, and there are others, certainly fit the bill for that. It's easy to sanction Honduras, frankly. But the countries where there's a superpower status, as we have with India, that's the time to, and Japan. I mean, these are very strong countries. That's when you say we speak truth to power. And I implore you to do this. And I hope the report will clearly name them as offending countries, non-compliant countries, but then take that next step with sanctions and then get the MOUs established. Please.
Can I tell you that we have 917 open cases as of March 17th, 2015?
And that's open abduction cases?
Yes.
Okay.
Is that abduction and access?
And again,
Abduction and access, sorry.
have you gotten word back perhaps on how many of the cases cited in your testimony were resolved with a return? I mean, just so members here and the press and all, because again, sounds like a much better number than it is.
We had 260 returns in 2014.
Okay, so about a third approximately of the cases were returned, the rest were not.
Right, but they might have been access. I don't have the numbers on the access.
And none from Japan?
No, none from
And
Japan.
India?
I don't think so.
And Brazil?
I know there were none from Brazil.
Okay.
Let
Okay,
me.
and the numbers, how many children are we talking about with abduction
I
cases?
do not have that.
Okay, please get back as soon as
I
you
will.
can.
But let me assure you that we will do everything we can to resolve all the cases to help every left-behind parent. You have my commitment.
Thank you. Anybody else have anything? No. Thank you, Ambassador. Appreciate it. And again, as you leave, I just again will say for the third time, please establish those MOUs. The mechanism
Sir,
doesn't exist.
We intend to approach those governments to do that. But remember that they have to be willing to negotiate with us. We need willing partners.
Again, I think that's where the sanctions will sharpen the mind, and they'll say,
I hope so.
the Americans mean business. I remember when we did the trafficking bill, and it took me 3 years to get the Trafficking Victims Protection Act enacted into law in 2000, and it took 5 years to get the Goldman Act enacted into law. I'll never forget meeting with members of the Russian Duma, and when we told them and showed them the sanctions provisions, one of the members who has been outspoken on combating human trafficking in Moscow said, "Oh, you guys do mean business. And will you implement it, though?" And I said, that remains to be seen as an executive branch function, but my plea to you is to use the tools in the toolbox, and we will get children back, and the custody will be decided at the place of habitual residence.
We will implement this law. You have my commitment.
Thank you so much. Okay. I'd like to now welcome our second panel, if I could, beginning first with Ms. Bindu Phillips, mother of an abducted children to India, Albert and Alfred, twin boys who are United States citizens and were born in New Jersey in 2000. Albert and Alfred lived in New Jersey just outside of my district prior to their abduction to India by their father, who took the family to India on the pretext of a family vacation. In spite of being granted custody of the children in the U.S. by the Superior Court of New Jersey in 2009, Ms. Phillips is unable to see or communicate with her children. She has been seeking justice in the U.S. and India to be reunited with her precious children for the last almost 7 years. We'll then hear from Mr. Jeffrey Morehouse, who is the sole custodial parent in both the U.S. and Japan of his son, who remains kidnapped in Japan. He volunteers much of his time as executive director of Bring Abducted Children Home, which is a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan. Through Back Home, he works to increase public awareness through outreach in the general community on the crisis of international parental child abduction. He believes it's important for parents of internationally kidnapped children to strategically engage in raising the level of awareness of this human and family rights crisis. We'll then hear from Devin Davenport, who is a research scientist from a biopharmaceutical company in Northern Carolina. But most importantly, he is the left-behind father of Nadia Lynn, who was abducted to Brazil by her mother in February of 2009. He filed a Hague return application immediately, which he won, and which has withstood appeals in court. But 6 years later, Nadia is still in Brazil. Although the special appeal at the Superior Court was finally rejected earlier this month, the taking parent continues to use delay tactics in order to prevent the inevitable return for Nadia back to the United States. And then we'll hear from Mr. Scott Sawyer, who is a father of a child kidnapped to Japan in December of 2008. 2009, he became an officer of the parents' organization Global Future, which has successfully, safely, and legally brought 5 kidnapped children back to their lawful homes in the U.S., as well as assisted in kidnapping prevention. Ms. Phillip, if you could be.
Mr. Chairman, if you don't mind, I just briefly, I would just like to say to each of you, thank you for being here, and I want to apologize ahead of time. I've got to step out for another meeting. It is nothing personal. I'll be here just for a few minutes. I do have staff here. We'll be monitoring and taking notes, but I didn't want you to think that it was out of a lack of empathy or concern. I thank you, Mr. Chairman.
Okay. Thank you.
Please.
Thank you, Mr. Chairman and distinguished members of the committee. It is my honor and privilege to testify before you today, and I thank you for your time to hear of my plight. My name is Bindu Phillips, and it's my ardent hope that my story will capture your attention today. While I've held many roles in life, none has been more meaningful to me than that of motherhood. 14 years ago, I was blessed to be the mother of twin boys, my precious children, Albert Philip Jacob and Alfred William Jacob. When my children were born, my ex-husband, Sunil Jacob, and I made a joint decision that I would stay home with them and be their primary caretaker. I was an active and loving mother in every aspect of our children's life. My children came first in everything I did and in every decision I made. Tragically, my world and that of my innocent children was violently disrupted by my ex-husband, Sunil Jacob, in December of 2008, when he orchestrated the kidnapping of the children during a vacation to India. I would note that the children, my ex-husband and I, are American citizens, and the children were born in America, which is the only nation they identified with as home. Sunil Jacob worked in the financial industry and was terminated by his employer, Citigroup, late in 2008. My ex-husband pressed me to agree to a family vacation to India during the children's winter break. My ex-husband was both physically and emotionally abusive to me, and I feared the consequences of refusing him. I had seen the return tickets dated January 12, 2009, and I had every reason to believe that we would be home in a few weeks to resume our life back in the United States. Had I known what would follow, I would have never boarded that flight to India. On reaching India, I was not only physically and emotionally abused by my ex-husband, but also by his parents. I was finally very cruelly separated from my children with no means to communicate with them. I could not bear the separation of my children, and on learning that my children were admitted to a local school in India, I approached the principal requesting that I be allowed to see my children, and I was granted permission. As soon as my husband learned about this, he transferred them to another school and gave the school strict orders that the mother or any maternal relatives should not be allowed to see or communicate with the children. Unable to communicate with the children, I ultimately returned to the United States 4 months later on April 9, 2009. I literally came home to an empty house. Our residence in Plainsboro was devoid of all furniture and possessions, and both the cars were gone from the garage. While in India, my ex-husband had 3 of his friends strip the entire house of everything inside. They took everything, leaving me with not even a single photograph of my children. He had not paid the mortgage on the Plainsboro home, nor the utilities, nor the equity line of credit, which he had transferred to India, and left me with this additional financial burden. Heartbroken and impoverished, I had to start from nothing and survived initially on the graciousness of good people. My neighbors allowed me to move in with them briefly, and a local church provided me a car. Shortly thereafter, I found employment, secured an apartment, and purchased a car of my own. Over the last 6 years, I continue to uncover information that shows how deceptive my ex-husband, Sunil Jacob, is. The investigation reports from the Plainsboro police station show that he had planned the move to India as early as March of 2008. He had communicated his intentions to the principal of the children's elementary school without my knowledge. In November of 2008, 1 month before the trip to India, Sunil Jacob obtained an Indian visa for him and the children, known as OCI, Overseas Citizen of India, that would allow him and the children to stay for an extended period of time in India, since the children are American citizens, and without an OCI visa, they can stay in India only for 6 months. Indian OCI visa is granted to minor children only after the approval of both the parents. Sunil Jacob obtained the visa by fraudulent means, as I have not signed on any OCI application for my children. Sunil Jacob, an American citizen, deceptively abducted my American citizen children and is staying in India out of my reach and that of the Hague Convention indefinitely. Please note, India does not honor dual citizenship. I also came to know that he is remarried. In 2013, Sunil Jacob's family member confirmed with the Plainsboro police that the separation of the children from me was planned well in advance. Frustrated but determined, on May 14, 2009, I filed a petition with the Superior Court of New Jersey for the custody of our children. Sunil Jacob tried to delay the matter by arguing that U.S. did not have jurisdiction to hear the case, but the American court, both the Superior Court and the appellate levels, have held that the jurisdiction was indeed proper with the Superior Court family part. My ex-husband was in contempt of the court order granting me parenting time over the children's winter break, although he participated on this hearing over the phone. The flight information was conveyed to Sunil Jacob. The Honorable Superior Court of New Jersey granted me residential and legal custody of the children in December 2009. The U.S. court order was served to Sunil Jacob by the U.S. Court and the Ministry of Law and Justice, New Delhi, India. The Plainsboro Police and the FBI have issued arrest warrants against Sunil Jacob. Please note, in 2007, while Sunil Jacob was working at Citigroup, he was involved in an unknown incident at his office that resulted in an FBI inquiry on him. His colleague told me when I returned that he had an affair with an Indian woman at his office. Despite having kidnapped our children, Sunil Jacob filed for custody of the children in the Indian courts after the U.S. child custody was filed. The case is currently pending at the Honorable Supreme Court of India. In addition to wrongfully keeping the children from me, Sunil Jacob has thwarted every effort I have made to speak to our children and let them know I love them. Beyond kidnapping, Sunil Jacob continues to file false cases against members of my family and me in India and is brainwashing and alienating the children from their own mother. He believes that if his campaign for harassment becomes too much for me to bear, we will back away from the quest for me to regain custody of our children. He must learn that this will not happen. He must be held accountable for his reprehensive actions. My children have lost 6 years of their mother's love and care, and I have lost 6 years of my children's childhood that neither of us will ever get back. Every day, I waken with the heart-wrenching reality that I'm separated from my children that I love more than anything in this world. I have done everything I can think of to do in this nightmarish situation, and I will never give up on my children. Yet, I am here because I can no longer fight the good fight on my own. I respectfully request you, the members of the Congress, help me to make my voice heard in a way that shall be meaningful and allow me to be reunited with my children who need the love and nurturing of their mother. Please help me put an end to the nightmare that Sunil Jacob has created for my family. Please help my precious children and me. I do not want to know and cannot imagine a meaningful life without them. Please act, not just on the benefit of 2 innocent children and their broken-hearted mother. Please think of all the other children and parents caught in similar nightmarish situation due to the hostile-minded parents who abduct children to overseas nation. I'm very thankful to Congressman Chris Smith and his staff for working so hard and passing the Sean and David Goldman International Child Abduction Prevention and Return Act 2014. I thank Congressman Chris Smith for being a champion for the noble cause of reuniting the children and their left-behind parents, and for being an angel to our children and to us, the left-behind parents. The Goldman Act was signed into law by President Obama on August 8, 2014. Goldman law instructs the State Department to take serious action when a case is pending for over a year, and my case is pending for over 6 years, and I'm waiting for the State Department to reunite me with my precious children. The State Department can also apply Section 201, which is high-level diplomacy and extradition of my children on my case now, and I'm hoping and trusting that they will do so without any further delay. I request the State Department and the Office of Children's Issues to take speedy action and to please implement the law as soon as possible and put a smile back on the faces of our children and us, the left-behind parents. Thank you from the bottom of my heart for accepting my humble request during your otherwise pressing schedule. Thank you so much.
Phillips, thank you so very, very much for your testimony and your example, which encourages all of us to do more. Mr. Morehouse, recognized.
Thank you to the chairman and the committee for inviting me here today. I will be summarizing my written testimony for you. There have been 400 cases of U.S. children kidnapped to Japan since 1994. the Japanese government has returned 0 children. On behalf of the 71 kidnapped children listed on the Back Home website who have been rendered voiceless by their abductors, for my fellow parents of internationally kidnapped children who feel marginalized by the lack of active, engaged, transparent assistance from the Office of Children's Issues in recovering their loved ones, I implore Congress to ensure that the Department of State finds Japan non-compliant and imposes sanctions under the Goldman Act. 1 year ago next week, at the very moment Japan acceded to the Hague Abduction Convention, parents joined together to hand deliver with us 30 applications for access under Article 21. This was supposed to be an efficient path to see our children again, though we parents may have applied for access under Article 21, as we were encouraged to do so by the Department of State, our collective cases remain abduction cases. Over the past 12 months, the Office of Children's Issues time and again insisted that we must give Japan time. We must wait and see. Well, we've waited, and we've seen. None of the back home parents have received any access to their children. Japan's implementation of the Hague Abduction Convention is an abysmal failure. Sanctions under the Goldman Act will provide some of the necessary public pressure on Japan to create change in this ongoing human and family rights crisis. It's crucial that members of Congress be made aware of the first Hague Article 21 access case to make it through the Japanese family court process. This case is typical of what parents are encountering in their attempts to gain access to their kidnapped children. Under Article 21, the central authorities are bound to promote peaceful enjoyment of access rights and fulfillment of any conditions to which the exercise of those rights may be subject. The central authorities shall take steps to remove, as far as possible, all obstacles to the exercise of such rights. Now, instead of removing obstacles, the Japanese government has erected multiple barriers interfering with the exercise of parental rights. These actions are prejudicial and designed to prevent victimized parents from gaining access to his or her children. The actions by the court in this pioneer case include, 1, a request by Henrik Tieton for interim access to his children under the Hague, which was ignored by the court. And 2, the judge walked out of the room when the father, who was representing himself, asked questions of the court. And 3, the father, who was denied the use of his own translator, was forced to use a court-appointed translator with no ability to ensure that the translations were accurate. Number 4, the judge refused to provide his name, therefore making accountability of his rulings impossible. And 5, the judge ruled that no observers, including embassy officials, were allowed to witness the proceedings. In my written testimony, I will also outline what some of the other parents have faced in their failed attempts to gain access. Now, in consulting with Japanese lawyers, it's become very clear to back home that Japan's implementation provides no reasonable, enforceable means for victimized parents to access or obtain the return of their children. They are simply violating the Hague Abduction Convention and non-compliant as a country under the Goldman Act. There are numerous clear-cut cases of abduction, such as Paul Toland and Paul Wong. Though they're both the only living parent, the grandparents in Japan are holding their daughters from them. There are cases like Randy Collins, whose ex-wife was ordered to surrender the child's passport to the court, and instead she kidnapped him. Douglas Berge's children were kidnapped from their habitual and legal residence in the United States in 2009, violating his parental rights to access. And Christopher Savoy's ex-wife violated the divorce decree, state and federal statutes when she kidnapped their children. Now, in my own case, I was granted primary custody of my son in the state of Washington in May of 2007. 3 years later, in June of 2010, I dropped my son Mochi off to begin a week-long visit with his mother. He was 6.5 years old. This is where my endless nightmare began. 6 days later, I received a phone call that no parent wants to receive. It was the police. My son and ex-wife had been reported missing. I knew immediately what had happened. She had succeeded in what she had intended on doing, which was kidnapping him to Japan. In that moment, my life was shattered. My days would become consumed with dealing with local law enforcement, the U.S. Department of State, Japanese consular officials, and anything I could think of to try and find my boy. Now, how could this happen to my child? I did everything I could think of to prevent this. There were even passport and travel restraints in the court order which barred her from leaving the state of Washington with him. Well, I came to learn the hard way that restraints are only effective if somebody is willing to abide by them. For someone intending to commit kidnapping, restraints have true little power. When the Seattle consulate of Japan denied my ex-wife's attempt to obtain a passport, she simply went to the consulate in Portland, and they issued her one in violation of the Ministry of Foreign Affairs passport issuance policy. And some people over the past several years have said to me, well, at least you know where he is. He's safe with his mother. But he's not safe. He is at risk. She has willingly and intentionally kidnapped him to a foreign land with the intent of permanently alienating him from me and everyone he knows. Now, imagine, just for a minute, being a child and your mother steals you away to a foreign country, tells you your father doesn't want you anymore, or that he's dead. Your whole life is now built on a foundation of lies. This is not what a healthy parent does. This is child abuse. Every morning I wake up twice. First time, I have this feeling I have to rush out of bed and get my son ready for school, and I can hear his voice, and he's saying, "Daddy, can I have toast and honey for breakfast?" And I have to get him ready for school. And then my heart skips a beat, and I wake up for real. And I realize he's still missing, and then the nightmare continues. The last time I held his hand, the last time I heard my son's voice, was on Father's Day of 2010. Last year in my case, I won a landmark ruling in Japan where the court acknowledged my U.S. custody order and recognized me as the sole custodial parent under Japanese law. My ex-wife has no legal custody rights there. They also cited her admission of committing illegal acts under Japanese law in order to abduct my son. However, they're still not telling me where he is. He's still being held captive. Private backroom diplomacy has failed. It's failed to return my son and any of the other kidnapped American children. Public statements by Secretary Kerry, Ambassador Kennedy, and President Obama could have meaningful effect. But to date, we've only heard silence. It's been Congress that has led the charge on this abduction crisis with Japan. And I urge members of Congress to ensure that the Department of State finds Japan non-compliant and that sanctions are imposed under the Goldman Act. Without public consequences, there will be no incentive for Japan to change. It will remain a black hole for child abduction. Now is the time for Japan to demonstrate they are serious about changing course on this ongoing crisis of international parental child abduction. Next month, Prime Minister Abe will come visit Congress and address Congress here in Washington. In addition to noncompliance and sanctions, I'm here to ask Congress to tell the Prime Minister that it's not acceptable to continue to hold Mochi Atomu Imoto Morehouse or any of the 400 kidnapped American children anymore. Thank you for your time today.
Ms. Morehouse, thank you very much for your very moving testimony. I'd like to now recognize Mr. Davenport.
Hello, thank you for having me here today. In the words of David Goldman on February 27, 2014 at the U.S. Senate Committee on Foreign Relations hearing on international parental child abduction, my foundation has been assisting a father by the name of Devin Davenport of North Carolina, whose daughter Nadia was abducted to Brazil in 2009, just a few weeks after her birth. Mr. Davenport has fought admirably to bring Nadia home. In September 2010, a federal court first ordered her return to the United States. Since then, the return order has been upheld by numerous appeals courts, and the legal case is effectively over, yet Devin is still waiting, as I did, for Brazilian courts to enforce their own return order and put Nadia back on a plane to the United States. Our government should be demanding, not asking, that Nadia be returned. I am Devin Davenport, the 28-year-old father of Nadia Lynn, and I still happen to be waiting for justice concerning her illegal abduction to Brazil some 6 years ago. I believe it has been made evident in the past via various testimonies from left behind parents and politicians that the issue of international child abduction is a great concern. However, it is absurd that after the immense effort to pass the David Goldman and Chris Smith's Goldman Act, that we must convince the U.S. Department of State, the sole governmental department responsible for assisting left behind parents systematically navigate legally through the Hague Convention Treaty, to effectively utilize the rhetoric, equipping them with necessary tools to increase resolutions for international abduction cases. The U.S. Department of State no longer lacks the necessary tools needed in order to optimize and create an efficiently robust pipeline for handling Hague cases and distributing pertinent information between left-behind parents and central authorities from opposing countries. Countless times throughout my 6-year legal battle, I've been the one to provide updates and ask follow-up questions in hopes of obtaining valuable information towards an actual resolution of my case. The Department of State is notorious for providing me with the exact same information I provide them with. Hardly do I ever obtain any new information, and I believe that derives from the fact that they are not proactive in their quest for justice on behalf of left-behind parents. An example is today, when you asked, how many cases, how many returns? They don't even know this type of information. They'll get it once you prompt them, but they should have came prepared with that type of information. They should know these numbers. This is what left-behind parents deal with on a daily basis, dealing with the Department of State. The inability and lack of foresight to initiate constructive yet progressive inquiries to the opposing central authority is not acceptable. Case officers working for the U.S. Department of State should not only be able to predict and questions and concerns of left-behind parents, but also take appropriate measures in obtaining the answer to those questions and concerns while providing feedback to those of us fighting the lengthy battle. The reason for this inability is the lack of empathy, initiative, and urgency, no longer the tools. Herein lies the issue. Until caseworkers at the Department of State are able to anticipate the next steps in a given Hague case based on years of internal evidential information from various left-behind parents in each country, then there will be no progressive action taken by them to provide information that some parents never think to ask but deserve to know, as we look to the Department of State as a source of information and mental solidarity. Since birth, on August 2008, my daughter Nadia Lynn resided with her mother Larissa Drummond in Cary, North Carolina. Due to parental alienation and prior threats to leave the country with my daughter to Brazil, a court order was filed and established August 20th, 2008, restricting the removal of my daughter outside of the state, as well as confiscation of my daughter's passport to prevent abduction. At the same time, a custody order was filed and signed on October 8th, 2008 by District Court Judge Walczyk and went into effect on October 14th, 2008, notifying each parent that it is a felony to transport the minor child outside of the state. The court order also states that it shall remain into effect until replaced by another parenting agreement or court order pertaining to custody. According to the signed court order visitation schedule between Larissa Drummond and I, October 14, 2008, our daughter Nadia Lynn was scheduled to have visitation at my residence on Mondays, Tuesdays, and Saturdays. On Saturday, February 7, 2009, my daughter was not brought to my residence for a visitation scheduled at 8 a.m. At 8:07, I immediately contacted Larissa asking where she was. After getting no response, I contacted her mother. I then called the Cary Police Department. Upon their arrival, I provided the court order visitation, and the officer and I went to Larissa's residence and found the house empty. With knowledge of prior threats made by Larissa to leave the country with my daughter back to Brazil, we contacted the U.S. Department of State to inquire about a possible abduction and were informed that I would receive a call on Monday, February 9th, 2009, from the abduction officer who handles cases to Brazil, who happened to be Ms. Daisy Cardale at the time. Soon after, I received NCMEC protocol number for my daughter, as well as a kidnapping case number for my daughter. There was a court order calendar by Wake County Courthouse to have my name added to my daughter's birth certificate. On February 10th, 2009, I filed to have an emergency order granting me sole legal and physical custody of my daughter Nadia, as well as the immediate return of her back to her habitual residence in North Carolina, which Judge Waldrop signed on February 12th, 2009. April 20th, 2009, the Department of State emailed me saying, "The Brazilian Central Authority would like me to inform you that your case was sent to Interpol on 2009, April 2nd. Furthermore, despite the fact that the child has not been located, the Brazilian Central Authority sent the file to the Federal Attorney's Office in order to commence an analysis on your case." April 19th, 2009, I received a message on the Bring Shine Home Foundation forum from a 21-year-old law student asking me about information on my daughter and the mother. I provided the last name, first name, and possible state that my daughter would be in. 8 days later, he provides me with the address of my daughter in Brazil. While it had taken Interpol and the FBI, four months, they still hadn't found her. I provided this information to the U.S. Department of State May 6, 2009. It took them 3 months later to confirm the address that I provided them. April 14th, 2010, I arrived in Brazil for the first instance hearing on the international abduction of my daughter Nadia Lynn. September 14th, 2010, I received a favorable ruling, which issued the return of Nadia back to the United States. I was ordered to spend a 15-day transition period in Brazil before returning. During this transition period, the mother filed an appeal, ultimately suspending the return as well as the transition period between Nadia and I on September 26, 2010. November 30th, 2011, the TRF Federal Court of Brazil rejected the mother's appeal by a majority panel. She appealed again within the federal court. March 23, 2012, the federal judge upheld the first instance court order for the return of Nadia back to the United States. The mother filed another appeal to the Superior and Supreme Courts. May 21, 2012, Special Advisor for Children's Issues, Ambassador Susan Jacobs, spoke to the Brazilian Central Authority directly and requested that my case be expedited and expressed her concerns on the delays and appeals that my case has received. April 11, 2013, TRF president rejected the appeal filed by the mother before the STJ and STF, and I was told that the request for the enforcement of my daughter to return back to the United States will be filed on April 30th. It was not. August 14, 2013, Ambassador Susan Jacobs and Scott Rayner traveled to Brazil to speak directly with proper personnel to have my case expedited and ruled on. However, I received no official report on this meeting. I have no clue what was discussed, with whom the discussion occurred, and what the outcome of said meeting was, although I was told that I would receive a formal detailed summary within 3 weeks. I was never sent that information. August 27, 2013, a hearing at the First Instance Court in Criciúma was scheduled, in which the charge of the enforcement order would decide the logistics of the return. Instead, they postponed this, and the appeal was dismissed at the SCJ Court in Brasilia, Brazil. September 6, 2013, the appeal was dismissed by the sitting judge at the SCJ Court in Brasilia, being that it was a monocratic decision. The mother appealed again. September 27, 2013, the Brazilian Central Authority and OAG filed a motion on the First Instance Court for the temporary execution of the enforcement order. This was a request that the judge not wait until the appeals were decided upon. The judge was to formally respond to this motion with a decision. October 11, 2013, I was informed that my case would be heard on October 17th. It wasn't. October 17th, instead of ruling on the appeal, it was removed from the agenda. April 14th, 2013, the STJ and STF appeals to the return order were rejected by the TRF president and were yet again appealed only once again to be dismissed by the STJ on September 10th, 2013, ultimately allowing Nadia to return to the United States once and for all, following a 15-day transition period in Brazil set to occur in 2014. June 17, 2014, I traveled to Brazil to complete the 15-day transition period with my daughter, with the expectation to return home once and for all to the United States. Upon arrival to Brazil, I was immediately served with another appeal, stating the transition period and the return order had been suspended by a last-minute injunction filed by the taking parent. I was able to have the suspension of the transition period overturned. However, the courts are still pending a ruling on the suspension of the return order at the STJ. December 15, 2014, Minister Rosa Weber of the STF court ruled in a monocratic decision to dismiss the special appeal. January 23, 2015, the taking parent filed a motion for clarification on the dismissal of the special appeal, a well-known delay tactic. January 28, 2015, I called the STF and asked that Minister Rosa Weber decide on this case as quickly as possible and to note the constant delay tactics being used by the taking parent. On February 11, 2015, I received an email from the Department of State stating that the ministers at the STF converted the mother's declaratory motion to a aggravo regimental. According to the OAG, this is a good sign as it shows a tactic from the court to accelerate the process. March 4, 2015, the special appeal at the STF was finally rejected. However, the taking parent continues to use delay tactics in order to prevent the inevitable return for my daughter back to the United States by filing yet another motion for clarification. I'm here today not to ask, but to demand that my daughter Nadia be returned immediately to the United States without delay. This case has literally taken its legal course, and justice is now overdue. I want to thank you for your time, and I hope that my daughter Nadia will soon be returned to the United States in her habitual residence once and for all. Thank you.
Mr. Davenport, thank you very much, and thank you for going through the process that you have followed. Like our other witnesses and so many left-behind parents, you have done it all by the book.
Yes.
And justice delayed is justice denied. Again, the three countries, and there are many others, but especially Brazil, Japan, and India, absolutely fit the criteria of non-compliant countries. And if sanctions are not imposed, and significant sanctions at that, again, they will take the view of that we are not serious about this child abuse, as Mr. Morehouse so aptly put it, that's being committed against your daughter and all of the other children. I'd like to now recognize Mr. Sawyer. The floor is yours.
Thank you, Mr. Chairman and Ranking Member Bass, for your ongoing support in this matter. I ask the Chairman's consent to submit my entire written testimony for the record and submit additional parents' testimony as well.
Objection, so ordered, and it goes for the others. Anything you want to affix to your testimony, please feel free to do it.
Thank you. Although his mother and father were divorced, my son Wayne benefited from the Los Angeles Superior Court's orders for equal time with both parents. I dropped him off to visit his mother on Sunday, December 14th, 2008, expecting to see him again on Thursday, and then bring him over to on the weekend, bring him over to the 26th Street Park in Santa Monica, where we would feed the ducks, which is something he enjoyed to do quite a bit. But he was kidnapped from Los Angeles and taken to Japan the next day at the age of 2 years, 4 months old. I have not been able to see him or speak with him since, and intermittent communications with his mother have not produced any change in that status. There are other aggravating factors in Wayne's case, including repeated deceptions by Japanese diplomats in the United States about the false passport that Wayne traveled under, along with his mother's on-camera confession to ABC News in February 2011, in which she chuckled on camera about how easy it was to deceive the passport surrender orders of the Los Angeles Superior Court, to deceive the U.S. authorities, and to get away to Japan. The government response to Wayne's kidnapping represents a perfect storm of failure. The LA Superior Court's custody, travel ban, and passport surrender orders designed to prevent his kidnapping were defeated easily by organized criminal activity. The court cannot, in reality, enforce its orders outside of the walls of the court. The DHS, TSA, and Customs and Border Protection do not have any serious system in place to interdict such kidnappings at the airports. The State Department has been discussing cases like Wayne's for over 20 years with Japan with no results. Even with all of the pressure and attention that this committee has generated over the years, the last several years in particular, there is, I believe, an obvious institutional drift regarding the roles of the Justice Department and State Department in international child kidnappings. And perpetrators exploit the absence of an integrated U.S. government response with little fear of facing justice. Let's, for example, contrast the governmental response to domestic interstate kidnappings. There are Amber Alerts, interstate police mobilizations, special FBI teams, systematic investigation, arrest, and leveraging of accomplices, apprehension of perpetrators, and frequent returns of the children. It is an integrated response, and there are prosecutions and deterrence. People would rightly be outraged if the states handled domestic kidnappings like the federal government and The Hague handles the international ones, for good reason. The law says that children like Wayne are victims of crime, no different than children kidnapped from California to Texas. On the state level, the Uniform Child Custody Jurisdiction and Enforcement Act says that international child kidnappings are to be treated the same as domestic ones across state borders. The legislative notes in the 1993 International Parental Kidnapping Crime Act state that the Justice Department should have primacy in international, that the Justice Department should have primacy in international child kidnappings with the Department of State in a subservient role. Now, since IPCA passed, the defined roles have gradually reversed to the point where the State Department, which is not a law enforcement agency, has taken the lead, and the Justice Department has filed fewer and fewer IPCA cases. A 2008 FBI Inspector General report found that the IPCA cases declined by half from 2000 through 2007. The FBI has the same affirmative duty under the law to investigate and prosecute international child kidnappings just as they do domestic child kidnappings. But because state practice does not file extradition warrants for IPCA cases, FBI agents are disincentivized from working up the cases. Now, state has received this quietly surrendered authority over the crimes, and in addition to that, 11 sections of the International Child Abduction Remedies Act, which was the U.S. Hague implementation law, has been removed from the U.S. Code and put under the State Department. We should also consider that the Hague's Best Practices Guide states that when there is a new contracting state, the first and primary choice for the central authority should be the Ministry of Justice or its equivalent. This opportunity was apparently missed when the United States acceded to the Hague and then named the State Department as its central authority. I believe this might have made a difference in the criminal kidnapping cases had justice in the first place been there. There is also this issue of conflict of interest. And to paraphrase Attorney Patricia Appy in a previous hearing, the client of the State Department is not the American citizen crime victim in the street. The client of the State Department is the U.S. government and its foreign policy objectives. I suggest that this chamber build on its expertise and its formidable work, and that future legislative goals of this chamber will be enhanced if it can fuse the successful approaches of the domestic kidnapping law enforcement model and the root principles of UCCJEA, IPCA, and Hague best practices into a rapid response whenever a criminal international child kidnapping takes place. In kidnapping crimes against children, I believe that the long arm of the law has produced more consistent results than the long conversations of diplomats. In 2009, I became an officer of Global Future. In 2010, we helped bring the two Mendoza children home to New Jersey from South Korea. New Jersey law enforcement took the lead with a very significant assist from the State Department. And in 2011, we helped bring Karina Garcia home to Wisconsin from Japan. She was the first kidnapped child ever returned from Japan through the criminal law enforcement process. Since then, we have helped 3 other children return from Asia, Europe, and South America. Of course, Japan's overdue accession to the Hague in April 2014 was not retroactive, and return applications could not be filed in cases like Wayne's. Since then, parents have been asked to then file access cases in Japan's New Hague courts. And for me, I find this particularly on the offensive side, is that Wayne would not be in Japan in the first place were it not for criminal acts committed on U.S. soil and from the mischief of a foreign government. The State Department has not demonstrated an inclination over the years to serve law enforcement warrants or extradition requests. By accepting this scenario, I believe the U.S. government has converted crimes against children into civil procedures and, in effect, conceded the criminal acts to the kidnappers. So the Assistant Secretary of State at the time, Kurt Campbell, said a few years ago that talk of extradition made Japan nervous. And by all means, let's start talking about extradition again and have law enforcement and the State Department working lockstep in tandem together, side by side. So Wayne is the victim of a crime with ongoing constitutional rights to due process in the justice system, and all departments of the U.S. government should treat him as such. The Constitution entitles him to equal protection under the law. He deserves justice like any other crime victim. He is not diplomatic chattel to be traded in exchange for unrelated geopolitical considerations. The President is also the nation's top law enforcement officer, and I would like to hear that someday hear that all U.S. government departments are committed to enforcing the laws as a strategy, as one of the tools in the box to return kidnapped children. In conclusion, I hope that the committee will take up the suggestion of a congressman made in one of the previous hearings of this committee, that the Foreign Affairs and Judiciary committees should have a joint no-holds-barred discussion and develop an integrated, sustained, and timely way to respond to international child kidnapping crimes. I believe the expertise and knowledge of this committee and of the Judiciary Committee is vast, separately and together. I have every confidence that the two committees working together will produce a plan of action that will build on your formidable body of work in this area and leave a legacy of fewer and fewer kidnapped children for generations to come. I would add that, of course, we've heard a lot of the parents suffering on this, but I would always remind people that no one loses more from these crimes than the children. Speaking for myself, I had a childhood. I have fond memories of both parents. My son does not have that because a crime was committed against him and so far has gone unanswered. Again, I implore both committees to work together, and I look forward to great success from both to come. Thank you.
Thank you so very much for your testimony. Ms. Bass.
Yes, I'm unfortunately going to have to leave, but I'm dying to ask you a question because, after listening to the testimony of the three individuals and hearing your story, I wanted to know if you could please explain how law enforcement could do that. I mean, today, you know what I mean? How you described a couple of cases, but in your case, what would happen? What would law enforcement do? In Santa Monica, they would go over to Japan?
Well, it was something that we talked about, some of us parents talked at great length with Kurt Campbell about when he was the Assistant Secretary of State. And the problem is that the FBI has been disincentivized from working up the cases. And what I've heard from the FBI is, if they're going to work up a case, they want to see it end with an extradition warrant. And if they're going to prepare the warrant and the State Department won't serve it, then why go work up the warrant? And then the parents.
Why does the State Department have to be? Because you describe. I think I understand what you're saying in the sense that if we go along the track of the State Department, then that disincentivizes. You're suggesting that we go along the track of the DOJ. And so why would they be disincentivized?
Well, that's it. As they work up the case, the FBI agents are busy in these child abductions. They've got domestic ones, they've got international ones, and then on the state-to-state abductions, they have vast success with getting extradition warrants from another state. The they prepare a foreign extradition warrant, and the State Department won't serve them in Japan.
So what can we do to change? Now, you proposed a hearing, but beyond a hearing, what are you suggesting that we do to remedy the situation to send it on that other track?
Yeah, I think that then your committee could then bring its influence to bear and get together with the Judiciary Committee. It is important to communicate that this drift that's happened has to be reconciled and brought back under the original intent of the IPCA laws and the UCCJEA, is that the United States has continuing jurisdiction in these cases, and our children's rights as crime victims do not change because they've been taken overseas. It's then with the committees working together and basically reminding each other that it is there's an affirmative duty for law enforcement to execute its duty. And then with those warrants, and what Kurt Campbell had said, the talk of that made Japanese nervous. That provides executing a warrant, and with it that is delivery ready, then gets the attention of the foreign government to where you can bargain. And the president is also the nation's top law enforcement officer. He says, hey, I got extradition warrants out.
So
for
new
these
legislation is not necessarily needed. It's just a new focus.
Yeah, I think better working together. The players on the field work together as a team, and we'll get better results.
Thank you. Appreciate it.
Thank you very much, Ms. Bass. Let me just, conclude. Just a couple of questions. Ms. Phillips, first of all, Eamon Blanchard is with you from the Plainsboro Police Department. I just would like to recognize him and thank him for the wonderful police work that his office and his fellow officers, he himself did, especially at your time of most vulnerability, when everything had been ripped off, and not only had you lost your children, you had a major act of theft occur against you. So I just want to acknowledge him and thank him. And let me just ask you, you did say that when you contacted the American consulate in India, one of the consulates, they said there was little they could do for you without an order giving you custody of the children, which you subsequently did get. Was there a change of effort on their part, an earnestness, a vigorous effort to facilitate a resolution to your case after that?
Thank you. Thank you, Mr. Smith. I did submit the custody order to the U.S. Embassy in India, and though they were very touched about my case, there was nothing they proceeded to do to help me get my children back. And I had also visited the Indian consulate in New York and spoken to the Indian consulate in Washington, D.C., and they advised me go to the U.S. Embassy and seek help from the U.S. Embassy in Chennai to get your children back, because all of you are American citizens and we can't do anything about it. I did forward that letter to the U.S. Embassy too, but I still haven't got my children back.
I just want to remind, and I do hope the press captures this if they include it in their stories, but the idea that there were 781 resolved cases, it does convey a false notion of resolved in terms of bringing children home. The number that with the update during Ambassador Jacobs was that there were 261, so that means 2/3 of the cases have not resulted in a child being returned home, and we know in Japan it's 0. It's 0 for 0, 0 for 400. Let me just ask you, all three of the countries that you have had your children abducted to, cry out as an engraved invitation for sanctions to be imposed after the report, which should be received by Congress or issued no later than April 30th, pursuant to the law, to the Goldman Act. What would be your reaction if the countries like Japan, like Brazil, like India, were not so designated and significant sanctions not imposed? Mr. White.
Mr. Congressman Smith, I think parents in our organization would be absolutely outraged if Japan is not found non-compliant. There's been no progress with the cases submitted for access over the past year. There have been significant roadblocks. Even today, when Ambassador Jacobs spoke about a return case where she suggested that it was imminent, my sources in the case are telling me that's in appeals. And we've seen appeals in Japan bogged down for a significant amount of time. So until cases are returned, Japan absolutely must be found non-compliant.
Yes, Mr. Davenport.
As far as Brazil is concerned, and I know you have a lot of experience with Brazil in helping David Goldman. As far as I know, no other children have really been returned successfully via The Hague. And we know what it took for Sean to return. And when you think about that effort and the immense amount of pressure that was necessary to be placed on Brazil for Sean to return, whose mother died, you know, it's crazy to assume that they would return a child whose mother is still alive without the same or more pressure from Congress in the United States. I believe that my case, for example, I've gone through the entire process. I mean, with every appeal that can be filed has been filed. It is essentially over, and my daughter is still over there. There's no enforcement. So you have a situation where you can win the case, and I'm pretty sure the Department of State would call that a resolution or a solved case, but the actual child has not literally been returned to the habitual residence. And that is the essential goal of the Hague Convention Treaty, is to actually have that child returned. And so until children are coming home, and it still boggles me that they don't know a number or no numbers. It's all, I'll get back to you. You know, I think that goes to show that there really probably aren't any cases where you can literally say a child has traveled from the country of abduction back to the country of origin.
If I may, Congressman, the sanctions is a fine idea. I've always believed that hitting Japan in the wallet is going to ultimately help us get further. But it also brings up another opportunity for this committee to work with others. There are a lot of outstanding issues and unresolved issues with Japan over non-tariff trade barriers. And you know, the beef, apples, rice industries are not too happy with Japan's policies in those areas, as are automakers and electronics makers. And coordinating with the other committees, and after the sanctions, coordinating with other committees to focus on the trade policy will be yet another lever to get Japan's attention.
I hope India would treat the child abduction cases as a criminal case and not a civil case. I wish, like, the U.S. government could educate the Indian authority and the officials there to have a speedy return of the children, and if they're having a case, to have it held quickly, because, as you said, like, justice delayed is justice denied. And my last hearing was in April of 2013, and I'm still waiting for the government of India to help me.
One of the questions, or series of questions I posed in July 28, 2011 to Ambassador, then Special Advisor Susan Jacobs, was about the closure of cases, because we always have had trouble with clarity in the numbers. Time and time again, I remember when we had meetings with David Goldman and Ambassador Jacobs regarding Brazil, we got different numbers, always different numbers, and it was hard to say what is the number, how many children, and hopefully the report will be very clear on the numbers issue. But I think it needs to be underscored, and for the record, I'll re-put this answer from the Office of Children's Issues into the record, that closure of cases follow: one, a child turns 16 in a Hague case; That's certainly not been a positive resolution. It just means the child aged out. And as we all know, that's what many of the abducting parents do through their endless appeals, like you're going through, Mr. Davenport, and all of you. The child turns 18 in a non-Hague case. The child is returned to the country of habitual residence. That would be a positive outcome for sure, but it's number 3 on the list. Maybe there's no reason for the juxtaposition, but it is number 3. The left-behind parent notifies the Office of Children's Issues that assistance is no longer required. The child or the left-behind parent is deceased. After multiple attempts, the Office of Children's Issues is unable to locate or communicate with the left-behind parent in order to obtain updated information or confirm that our assistance is still required. So there, cases drop off the table because, again, a child turns 16 and his age is out. When it's presented in an aggregated form, it could be very easy to have a takeaway, oh, the cases are going down, or these have been resolved successfully, when that is absolutely not the case. Let me also just say that I think, again, all 3 of your cases, absolutely, your individual cases, not the larger numbers which you all represent, Section 201 could be applied to every one of them, and ought to be. This is a serious attempt, the Goldman Act, to hold countries to account. Unfortunately, we have 4 votes pending, and I'm going to have to end the hearing very shortly. But let me just, if there's anything you would like to add, again, your comments, Mr. Whitehorse, about Morehouse, I should say, about Hendrik Teton's case, Teton's, that the judge refused to provide his name. I've had 15 hearings on human rights in Northern Ireland, on policing and on dip block courts. I can't think of another instances in a country, particularly Japan, a mature democracy, where a judge will not utter his name in his own courtroom. In the dip block courts, they used to shroud the judges so nobody knew who it was that was deciding a case. Here in Japan, Mr. Teton had to put up with the 5 points you made, which were devastating, one of which was the judge refused to provide his name. That's outrageous. That's almost laughable, but it's certainly not funny. So if any of you would like to provide any further comment before we have to close down, I do want to just acknowledge, first of all, that David Goldman is here. And David Goldman, as I said in my opening, has been a tenacious, like you, father, mother, who cares so much about his son or sons or daughters that he fought, and in his case, thankfully, yielded fruit, and Sean is doing extraordinarily well. I meet with him all the time, as well as with David. He and Mark DeLangelis are both here, and Mark has spent so much time volunteering and doing work for the Bring Home Sean Foundation. And Mr. Davenport, as you know, they've been helpful to you, and so I want to thank them. Patricia Appy, who's not here, but a lawyer who helped us with many of the finite details of the bill, particularly as related to DOD, and she had extraordinary expertise to bring to bear on that. David Feimster and Gail, his wife, who were successful. Sometimes a Foreign Service officer is dogged, and that was the case in Tunisia. And I just want to acknowledge that we're grateful for the work that their Foreign Service officer did in helping to bring Mr. Sweeney, Michael Sweeney. And I did talk to him on the phone a few times. He was absolutely locked onto the case, and those kids came home. So I want to thank all of you for, let me conclude, and then you'll all have the final word. At one of our hearings in 2009, Bernie Aronson, the Assistant Secretary for State for Inter-American Affairs between 1989 and 1993, provided some very powerful testimony. But one of his points, which I thought was just so telling, here's a man, Assistant Secretary, sat in that very important, influential position at the U.S. Department of State, and he said, let me quote in pertinent part, "Let me be blunt. A diplomatic request for which there are no consequences for refusal is just a sophisticated version of begging. And there are no consequences today for Brazil," and I would add for these other countries as well, my own addition, "or any other nation which refuses to return American children." Those words are no less true today, but now we have the Goldman Act, where there can be and must be significant consequences for refusal, and to end this sophisticated version, as Bernie Aronson put it so eloquently, begging. Final comments, very briefly, if you could, and then the hearing will adjourn. Bindu? If you'd like. If you don't, that's fine.
Yeah, I would like to thank you so much for helping us, and I would like to request the Indian government to please help us be reunited with our children, and to understand our pain, and to understand that the little and helpless children have no choice but to listen to the abducted parent, because that's the only family they know, and they can't do anything against the abducted parents. So to please help us, and the same with all the countries where the children have been taken.
Thank you.
Thank you.
Mr. Morehouse.
Yes, I'd like to just reiterate for the committee that although we have applied for access, our cases do remain abduction cases. There have been no children returned, and until they are returned, they are still kidnapped.
Thank you. Mr. Davenport.
I'd just like to say that sanctions are absolutely necessary, especially for countries that are non-compliant. And the risk of diplomacy is definitely necessary to apply that to these countries in order to bring the children back. One instance will set an example, and maybe threats from there on out will be enough. But you have to make good on a sanction, at least one time. At least bring a child home. Sean Goldman's the only one I know of. Thanks.
Thank you, Ms. Davenport. Mrs. Sawyer.
I remember Mr. Aarons's testimony quite well, too. It was really outstanding. I'd say, speaking of consequences, sanctions are terrific. I would say with sanctions and with the coordination with law enforcement, serving extradition warrants, those two things together are mutually supportive of each other. You'll get more bang out of whatever sanctions diplomatically by enforcing extradition warrants and vice versa. I think it's a really terrific idea, and putting those two together will really get Japan's attention. And as far as extradition went, we saw that legal extradition process work in the Karina Garcia case in Milwaukee, and that's a model to build on. And I look forward to the two departments cooperating. Thank you.
Thank you. This is the first in a series of hearings, so I want to thank you for your extraordinary testimony, love for your children, and we will never quit in trying to bring your children home. Hearing's adjourned.
Nice to meet you too. Could I have your number? Could I have your number?
Yeah, sure.
Oh, thank you.
Just email me or give me yours and go
Okay.
next to you.
Oh, okay, okay. Consular affairs. Oh, okay. And is the division chief here?
No, he's not. Okay. But are you in consular affairs? Yes. This is
Patrick Ray.
Hi, I'm Deb McFarland. I'm one of the Japan country officers.
Oh, okay.
she does, but she.
What do you do? Are you in the political side?
No,
You're in consular affairs, I'm sorry. Oh, you're, okay, southern half, not Tokyo. Okay, all right.
That's why she doesn't.
So they mentioned there was a return, right? They mentioned there was a return out of.
We have several attorneys. That was Dara Mornoff.
Who was that?
She was the one on the end of the table.
How long ago did you guys get that?
R.A.
You got through that without crying.
M.O.R.A.
When did you get the petition?
N.O.F.F. Yes.
Was it one of those?
You're welcome.
Of just this last, oh wow, so it's a fresh one. Good. I just got a new case today, but it's a prevention so far, but it's pretty high risk. High risk.
With me, I'm sorry, Ambassador Jacobs
Do you
had
have a
stack and then
your
put
card?
they were in her pile when she left.
There's been people named
I'm not the officer for India though. But who are you in touch with?
Ryan Sandler.
Ryan Sandell? Okay. It's Ambassador Jacobs will make sure you get what you need. I'll follow up with this, okay?
Face with the name.
Okay.
Yeah, right.
Enjoy the rest of your DC activities.
Okay, thank you so much. Have a wonderful day.
Yes.
Excuse me.
Oh, yeah, right. Are you new?
I'm not new, but why I'm here specifically for this hearing is that I have been working on implementing the law in our office. The project. Okay, that's why I'm here.
The smile is making me feel that we will get them back.
This is ICARA or I have no idea. That's an attorney advisor question.
Well, it's actually part of the law. It's part of the State Department certification.
Have you talked with him?
March 15th.
No, like he's trying to eliminate, right? Because they are all have to ask our attorney advisors because even that's part of the implementation.
They don't make
more straight than me.
No,
My parents
we
keep
know
saying,
the
yeah, you were very
law
straight, you were
quite
very
well.
straight. You are much
But
more
that would
straight.
be something
He made her sign papers, she would sign away the house and God knows what.
our legal advisors would definitely be the ones in charge of that.
But that's not. Who's the legal advisor?
Do you know who's Robbie and We have several attorney advisors that are working on this issue, yeah.
Who's the lead? Who's in charge of it?
I speak with 3 attorneys, so Dara Warnock, we have Lisa Vogel, Shannon Rayburn, extensively. Yeah, yeah.
Maybe I'll send you.
I don't have a card on me, actually.
Send me. I can forward it.
We got Marco.
Yeah, you can.
Council Affairs.
She's also an expert on the Goldman Act. We call it like
Oh, good. Right. I've had a lot of contact with my mother's Civil War contact. Yeah, whoever's on the phone from the embassy staff in Tokyo is regular. Yeah, it's really terrific. I'm always, that's what I'm always pleasantly surprised. I always like to hear the news when they've got she's talking about.
So that's been a real setback for us. Okay. I don't know, Ryan. He said he was coming. Okay.
See, that's diplomats. That's a diplomatic skill.
Okay, well, you'll be with me in contact tomorrow at 10:30 or whenever time you, I know you have.
you're gonna
That's great. I appreciate Right on. That's right.
Yeah, I should say goodbye to this weekend tomorrow. Thanks very much. Absolutely.
Sorry, I had to go. Thank you. Good to see you. Thanks for being here. Appreciate it. Thanks for
It was great to meet you.
Likewise.
Yes,
Thanks
thank
for
you for
being
your
here.
It was
testimony.
really a pleasure to meet you, Mr. Wilson.
Thank you so
And
much.
hopefully we can push on.
Well, that's what we need to do. We break it down and more people can.
my card.
Likewise. Likewise.
Anything you know, I can do.
Yeah. Thank you. Appreciate it. Just the people.
Here's a my.
I'm sorry. I gotta do it. Japanese princess here. Speak. I understand how unfortunate it is. But thank you again.
Take care.
You too. I'll be in Washington this week, so if anything comes up.